Welcome to the debate. Our focus today is Article 3 of the Constitution, specifically the foundation of the judicial branch, which, as we know, vests all judicial power in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. And the core of the matter, really, and what we'll be debating, stems from this critical tension that you find within Article 3, Section 2. You've got the Supreme Court's appellate jurisdiction, which is granted with such exceptions and under such regulations as the Congress shall make. So the big question is this: does that clause give Congress definitive structural power? The kind of power that includes the ability to, say, prevent the court from hearing entire classes of cases. Sometimes people call that jurisdiction stripping. Or is this exceptions power functionally constrained by that prior seemingly absolute vesting of the judicial power back in Section 1? So my position is that the text really does grant Congress the necessary broad authority it needs to control the scope of appellate review. And I see this control as a vital legislative check on, well, an unelected judiciary.
Yeah, I see that textual argument. I do. But I tend to approach this more from a structural perspective. My position is that the initial grants of jurisdiction, the mandatory ones, the list of cases the judicial power shall extend to, these impose a functional limit on that exceptions clause. Because if we allow Congress to just strip jurisdiction entirely over, say, constitutional matters, well, then we risk undermining the court's whole purpose. It kind of turns that promise of judicial independence into, well, an empty formality, doesn't it?
Okay, let's start maybe by grounding ourselves in the actual language of Section 2. We often talk about checks and balances, right? And the text here seems to provide a pretty clear, explicit mechanism for checking the scope of the judicial branch. So the Supreme Court has appellate jurisdiction over the vast majority of federal cases, those arising under the Constitution, federal law, treaties. But crucially, that jurisdiction is explicitly qualified, with such exceptions and under such regulations as the Congress shall make. Now, the power to make an exception, inherently, that sounds like a power of exclusion. It seems to allow Congress to carve out specific areas. And given that the justices have lifetime tenure during good behavior, well, this power seems designed to ensure they remain somewhat accountable to the democratically elected branch, at least regarding the operational scope of the judicial system. I see it as a purposeful design feature, not some kind of oversight.
Right. I see why you emphasize that structural balance and accountability is important, of course. But let me give you maybe a slightly different perspective. If we interpret the exceptions clause as granting truly plenary power, doesn't the entire judicial architecture kind of collapse into legislative supremacy? Remember, Section 1 vests the judicial power of the United States absolutely. That power isn't just a label. It feels like it has to be a functional mandate. And it's supported by things like the promise that a judge's compensation shall not be diminished. You protect the personnel, presumably to secure the function of the office itself. And that list in Section 2 covering cases arising under the Constitution, it's mandatory language. The judicial power shall extend to them. So if Congress can just strip jurisdiction over all cases that might challenge the constitutionality of its own actions, well, then the constitutional guarantees themselves become effectively unenforceable, right? We risk having a Supreme Court that, sure, it can rule on maritime law and treaties, but is legally blind to potential abuses of power by the political branches. And that, to me, makes the initial grant of judicial power almost meaningless.
But we really have to grapple directly with the meaning and the extent of that word exceptions. If the framers intended this power to be restricted only to, say, minor procedural adjustments, they were perfectly capable of using more limiting language. They knew how. Instead, they used a word exceptions that just inherently suggests the ability to exclude entire categories. And consider the alternative interpretation, the idea that Congress can only regulate how the court hears cases, not which cases. If that were true, wouldn't the word exceptions be sort of redundant right next to regulations? You just need regulations. Plus, the only guaranteed jurisdiction the court has is its original jurisdiction, cases affecting ambassadors, states as parties. And that's very narrow, and it's listed separately from the appellate jurisdiction, which is subjected to this congressional caveat. That structural difference, to me, strongly implies broad legislative control over the appellate function.
Okay. I think maybe you're placing a bit too much weight on that single, isolated word exceptions and perhaps ignoring the broader constitutional context. The exceptions power, it seems to me, must be interpreted against the foundational grant that the judicial power shall extend to these crucial areas like constitutional review. I mean, the whole point of separation of powers is to ensure checks are internal and balanced, not that one branch can effectively dismantle another's core function. Think about it this way. If Congress wants to pass a law, let's imagine, some highly controversial measure, maybe a massive new federal regulatory scheme, and then it passes a separate law saying the Supreme Court simply cannot review the constitutionality of that first scheme, well, we've fundamentally disrupted the balance, haven't we? That feels less like regulation and more like self-preservation by the legislative branch, potentially at the expense of judicial review itself. So the exception power, if we want to maintain structural integrity, it seems it must be limited to removing perhaps subsets of cases in ways that don't compromise the court's essential function as the final constitutional arbiter.
Okay, let's pivot slightly and look at the role of these structural guarantees versus the enumerated controls. You highlight tenure and salary protection as key evidence of independence, and they are. But I'd argue that this protects the person of the judge, yes, but legislative control protects the integrity of the whole institutional system. I mean, look at the biggest structural control Congress holds: the power to ordain and establish all inferior courts in the first place. Without Congress, there just is no lower federal judiciary. Full stop. Furthermore, Congress controls the size of the Supreme Court itself. They've changed the number of justices multiple times throughout history. This really shows that the fundamental architecture of the system is entirely dependent on legislative determination. So the power over appellate jurisdiction, from this view, is simply another enumerated component of this overarching legislative authority to define the scope and structure of the court system.
That's a powerful point about Congress's architectural control. It absolutely determines the number of justices, the structure of the lower courts, no question. But I'm still not convinced that controlling the institutional architecture allows Congress to just nullify the constitutional function once that court is actually established and running. You know, judicial independence seems to demand an effective scope of review to mean anything. Why protect a judge's salary for life if Congress can just eliminate all the crucial constitutional work they are actually meant to perform? Think about the trial of all crimes except impeachment, which Section 2 says shall be by jury. That's a procedural guarantee placed directly on the system that Congress can't just override. And I think, similarly, the ability of the Supreme Court to perform judicial review could be seen as an implied, almost necessary procedural guarantee of the judicial branch itself, regardless of who sets the number of benches or who pays for the building's electricity.
I think maybe you're conflating two different things there. The protection of individual rights, like the right to a jury trial for crimes, with the structural allocation of power between the branches. Those feel like two very different kinds of constitutional concerns to me. And look, if the intent was truly to ensure some unreviewable core constitutional scope for the Supreme Court, the framers absolutely knew how to impose rigid, unmistakable limits on legislative power. We see this kind of restraint explicitly applied right there in Article 3, Section 3 concerning treason. Treason is defined incredibly precisely and narrowly: levying war against them or on adhering to their enemies, and it requires very specific proof: 2 witnesses to the same overt act. Now, that is a rigid constraint on Congress's power, specifically its power to define a crime. The fact that we see no similar rigid constraint applied to Congress's power over appellate jurisdiction back in Section 2, well, that strongly suggests that broad legislative discretion was intended here, perhaps precisely as a political check. The constitutional framers were certainly aware of the possibility of judicial overreach, and maybe they built in this mechanism specifically to curb it.
That's a compelling point about the specificity in the treason clause. I grant you that. But Section 3 limits the legislature's definitional power, arguably to prevent the political abuse of criminal law itself. That seems fundamentally different from jurisdiction, the power to hear a case. Furthermore, if you look at historical attempts at, let's say, massive jurisdiction stripping, think about the period after the Civil War, the whole ex parte McCardle context. It often seems that Congress only really succeeded in limiting jurisdiction after the Supreme Court had already clarified certain key constitutional principles. The power has maybe arguably historically been used more to manage the docket rather than to completely abolish the court's essential functions.
The structure of Section 2 puts the mandate first. The judicial power shall extend. The exceptions power reads like, well, the deviation from that fundamental rule. If we interpret the exceptions clause too broadly, aren't we essentially inviting a kind of structural collapse by allowing one branch to potentially incapacitate another? The whole principle of constitutional supremacy seems to require that the branch designated to interpret the Constitution actually be able to do so, regardless of whether the legislature is uncomfortable with its anticipated rulings.
But if the text provides the power, well, we have to respect that text. The constitutional design is arguably one of calculated friction, of tension. Congress's power of exceptions and under such regulations over appellate jurisdiction might not be a flaw. Maybe it's a feature. It could be there precisely to ensure that the federal judicial system, while independent in terms of its personnel, is structurally beholden to the legislative branch when it comes to defining its docket and its overall scope of review. And maybe this is what prevents the judiciary from becoming a kind of sovereign power unto itself.
Well, while Congress's power to regulate the docket is, I think, undeniable, setting procedural rules, controlling case volume, things like that, that power, in my view, cannot extend to completely extinguishing the Supreme Court's core responsibility. The mandatory grant that judicial power shall extend to constitutional cases, when you couple it with the guarantee of tenure and compensation, it really confirms for me that this power has to have limits. It must, at the very least, safeguard the judiciary's essential ability to interpret the Constitution and uphold the rule of law.
So it seems the material clearly establishes a rigorous framework for the judicial branch, yes, but it absolutely leaves the precise demarcation of that regulatory power and therefore the true scope of judicial independence open for careful and, I suppose, ongoing examination. This enduring tension really ensures that the balance of power remains a dynamic concept, not something fixed in stone.